The following is a paid commercial announcement. The ideas and opinions addressed in this show do not reflect the views of WKBK or Saga Communications. From the Davis Oil and Propane Company studios, it's time for Financial Wellness Weekly. The opinions voiced in this broadcast are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine which strategies or investments may be suitable for you, consult the appropriate qualified professional prior to making a decision. Time now for Financial Wellness Weekly on WKBK.
Securities and investment advisory services offered through LPL Enterprise, a registered investment advisor, member FINRA SIPC, and an affiliate of LPL Financial. Financial professionals are licensed insurance agents of Prudential. These financial professionals are permitted to brand under Prudential. LPLE and LPL Financial are not affiliated with Chartered Financial Services or Prudential. Individual tax and legal matters should be discussed with your tax or legal professional. Economic forecasts set forth may not develop as predicted, and there can be no guarantee that strategies promoted will be successful. All performance referenced is historical and is no guarantee of future results. All indices are unmanaged and may not be invested into directly. There is no assurance that the techniques and strategies discussed are suitable for all investors or will yield positive outcomes. The purchase of certain securities may be required to affect some of the strategies. Investing involves risks, including possible loss of principal.
Welcome back to Financial Wellness Weekly on Keens News Station, WKBK. Saturdays we are on at noon, and this is Chartered Financial Services. I am Nina Benton.
And I am Liz Newcomb.
Welcome.
We're happy to be here, and today we are planning to talk a little bit about estate planning.
We do. We are going to speak about that. What do we do for some people perhaps who have missed our introductory sessions that we've had? Do you want to tell them a little bit about us and a little bit about what we're here to do?
Absolutely. I think that's a great idea. So we are a financial planning firm in Keene, New Hampshire, and we help people with all aspects of financial planning and investments and protecting their families, perhaps with different strategies. But on this radio show, we're really here to give general financial education and to help everybody to maybe learn a little bit more about financial wellness and maybe make a couple of steps in the direction towards financial success for themselves and their families. And we want to hear from you. So if there are topics that you are interested in learning more about, or if there are questions that you have after hearing something on the show, we would love to hear from you at CFS. That's C like chartered, F like financial, S like services at prudential.com. But again, today we'll be talking about estate planning, and we'll look forward to sharing all kinds of different episodes in future about various topics.
Awesome. That's terrific. Thank you for that. So estate planning, it's a topic that is a lot of people don't address because they don't think they have to, because they feel that estate planning is only for the wealthy.
Or they don't want to think about death.
Yeah, that's another reason why people also don't think about life insurance, right?
Absolutely.
Yeah, so those are two things. We try to hold your hand, maybe give you a hug and walk through it all together in a secure place. But
Right.
it's something we need to plan for the worst and hope for the best.
Absolutely.
Yeah.
And we should headline that we are not attorneys. We're not going to be able to draft estate planning documents, but we are general practitioners, and we know about the types of documents that you should have in place and the types of planning that you should do to protect yourselves and to make sure that your assets go to whom you want them to go to, when you want, and the way that you want. That's
so
really what
important.
it's all about.
It's truly all about control and protection. And
making sure your wishes are honored.
Yeah.
Making sure you don't leave a mess as well.
And how stressful is that if anyone has ever lived through it, when there is a death and nobody knows what the person would have wanted, or families start fighting over things.
Or you're waiting for things to come in the mail just to find out what accounts your loved one had.
You have to be a detective for sure. Very difficult. Or what bills are overdue by getting all of those statements. Yeah, it's it can be very devastating, not only emotionally, but financially, if things are not tended to and looked after.
Right. Well in advance, because you just never know. We all want to be here until our late 80s or 90s or maybe 100.
Like our grandparents.
Exactly. But these things you need to think about early, because something tragic could happen at any moment, really. So.
Unfortunately, very true.
Yeah.
Very true. And I'll share some stories, as will you, as we go through these things where that happens. And we're just so thankful that we were able to put things in place. So why is it needed? We've started to talk about that. It's not just about taxes, as most people think estate planning is. Now, what is an estate? The very basics. If you own anything, the ring on your finger, the jewelry that you wear, the clothes that you have, your car, right? Your house, if you own a house, books, anything that you own, what would happen to that if you should no longer be here, or if you become incapacitated? What would happen, not only to you, but to those assets? So these are the reasons why we need to document. And it's not a plan to say, oh, I told my brother, oh, I told my sister, they know what I want to have. That's not official, unfortunately. And we'll go into why exactly that's not official.
Right.
Because there are rules that you do have to follow when you look at the official estate planning documents. So to get us started, when you start thinking about estate planning, what are some of the things that we need to think about? So who should inherit your assets? Think about the people you know, your friends, your family, relatives, organizations. Who do you want to inherit? And remember, from some of our last sessions, I always say, think about the end in mind. And that's exactly what we're doing here, is what do you want to have happen to these things? Who do you want to have them? How are they going to get it? Are people going to get things plopped in their lap all at once, or are things going to come in a dribble fashion? So,
especially important when you have children.
Very much so. So if, for example, and this is a tease for what we'll speak about beneficiary listings and the importance of them, because a lot of us look at these things as impositions. I don't know how to do this. I'm just going to put, if you're married, you might put your spouse and then maybe not have a contingent beneficiary. A contingent beneficiary is someone who would inherit it should something happen to you and the other person who is your primary. Or not put anything. And then the default is put as the contingent, so that should something happen to myself and my husband, either in a plane crash or a car accident, and I didn't have any
backup plan,
then it's going to go to the estate. We're going to talk about what that means, what will happen if that's the way I left it. Or, as Liz said before, if I did put my children as the contingents and I pass away, and I've done a great job in savings, and my husband and I, have an accident and are no longer here, well, all of that money would go plop into my children's laps if they are of age. And if they're not of age, that's a whole nother problem, because the financial institutions will not put money out to minors until they are of age. And so who now is going to do it? And that may be where the state steps in to give you, if you have not named a custodian or a guardian for those children in these documents. And that's part of what they do.
Right. And you don't want to leave any of that to the state to decide. You want to be thinking about those things and making sure that you've planned ahead for that scenario.
Exactly. And what if some interesting circumstances, what if there are some special needs or elder care issues? If I'm taking care of a child and I've gone through all of the regulations and the procedures to have some subsidies or to have them qualify for certain government payments. If I leave them money, it may make them now ineligible for those things. So we need to make sure that we properly leave these things. Yes, I can still leave money to them, but it should be in a special needs trust that stipulates exactly how I want those dollars to be used. And it would say, an attorney does this, what would not be used for would be anything that those other proceeds would have taken care of. So very specific things that we can speak to and plan for and work towards. So what can estate planning help? What are the things that we can address with estate planning, Liz?
Well, I mean, it can certainly address concerns about taxes.
Right. Yeah.
It can also help determine if a simple will or trust is enough, and whether you need a trust or not.
And we'll talk about that as we go more deeply into this. Yes.
Yeah. It makes sure that things go to whom you want on your timeline, right?
Yeah, that control factor again.
Right.
Yes.
And again, to not leaving a mess. I mean, you don't want your loved ones trying to do guesswork and then needless paperwork and running around stressed and trying to gather things and, paying for probate and waiting a year sometimes just to be able to get access to assets that you might have wanted them to have right away.
Yeah. I find that I'm doing more and more financial plans on clients who are coming to me saying, I need to have a good listing of all of my assets, where they are, who owns them, in case something happens to one or both of us, so that my spouse and the rest of my family knows where everything is and knows where all of the different components are.
Yeah, it's like an inventory. It's
is.
going to help you create an inventory that just takes out the guesswork and the questions for your loved ones. But it's also important during your lifetime to have done this planning in advance, because part of the estate planning process is going to involve powers of attorney and medical directives.
Right, and we're going to talk about each of those and go more deeply into them, starting with the wills and different things. But let's talk about, before we jump into the documents, what are the different ways that assets get transferred upon death? You had mentioned probate. So let's talk about what is probate and what are assets that get transferred through the probate system, and how can we be more efficient and try to avoid that probate system?
Well, I think that's the key right there, Nina, is that we want to try to avoid probate at all costs.
Okay. So it's like a dirty word.
Yes. It's costly, it's timely, it's complicated. So non-probate assets are those that don't have to go through that probate process. And this would be specifically things that you have a beneficiary named on.
Okay. So beneficiary listings mean that it will go directly to the beneficiary and it doesn't have to go through a court system.
Exactly. Beneficiaries trump a will, and they save the time and the hassle of going through probate. So you pass away and you had your daughters named on your accounts, and they call me and say, hey, so-and-so's passed away. I'm the beneficiary. What do I need to do? We work with them directly. We get the death certificate. We gather proof of identification, and then we can make sure that those assets go directly to the beneficiary with no waiting.
That certainly speeds up the process. So assets then that go through probate, and we'll discuss what probate is, are assets that have to go through the will. So assets that do not have a beneficiary listing on it. So let's name what has or should have, because that's a whole other topic, should have a beneficiary listing. Your IRAs.
Your bank accounts.
Well, do bank accounts have beneficiaries?
They would have a TOD or POD typically.
Okay, so if I have, because a lot of people don't know this, so they typically know that 401ks, IRAs, life insurance, annuities, those tax-deferred vehicles typically have, and you have to have beneficiaries listed on them.
You should.
And we'll talk a little more about that because they don't always stay on there. You can't just put them on and never look and make sure that they're still there. But bank accounts or investment accounts where I have the money in my pocket and I decide to invest in stocks or in CDs or just put the money in cash in a bank, those typically do not have a beneficiary. So, Liz, how do we get a beneficiary on that?
So those non-retirement accounts are just typically, like you said, individual accounts. And so the way to do that is to make sure that you add a transfer on death or a payable on death.
So a TOD or POD, depending on the institution. They'll tell you what they do. And it's simply a form, just like a beneficiary form. And then it turns it into not going through the will, but having a beneficiary designation more efficient. So,
Exactly.
So what is probate? Why do we want to avoid it? What is the process that happens with probate?
I mean, it's a court process, right? So
So we
the
get
first thing
an
to know.
administrator assigned to our case.
Exactly.
And then they have to validate the will.
Right.
They have to look at all the assets. And it is a public process, right?
Yes.
They then put out a calling and say, so-and-so has passed away. If you are owed something, if you feel you're related and do something, come step forward. So there's a waiting period after they announce it and all the assets get identified. So very public, and it can take time, money, and the assets are frozen during that period of time.
Right.
So to avoid that, the beneficiary is private, correct? They just came to you. You don't put an announcement out.
Right.
So that's such a better way to do it. So lesson number one is ideally we try to have beneficiaries on all assets.
Yep.
Okay, so we want to avoid that. Got it. So what's a will? Let's talk about a will. What does it do then?
So, I mean, a will is important, right? Because there are going to be some assets that, for example, your jewelry, where you can't really name a beneficiary on your jewelry. There's always going to be something. So the will can serve as a catch-all in that sense, where it gives instructions on how you want all of those things that maybe can't have a beneficiary listed, how you want them handled. But it could also have important instructions about things such as guardianship for children. Can't exactly put, put those instructions anywhere else other than a will, really. Trusts are something we'll talk about too.
Right.
What else, Nina?
Well, as you said, the guardian naming an executor or executrix for the estate. So that's where somebody will be overseeing everything and in charge of making sure that the wishes that you wrote down
are honored.
Exactly. Yeah. And they're followed so that they are the ones, they make certain tax decisions, filing, things like that.
And you often will know of your close loved ones who would be the best for that role, who has the personality for that, who has the energy, who has the willingness, because it does take time and work to inventory things and to gather these documents and make these decisions. And you don't want just anybody doing that.
It is an obligation. It is. It's not, you may think it's an honor to name somebody. It's actually an obligation. But if you pass away and you do not have a will, that is called dying intestate. And if you die intestate, depending on the state in which you lived, that's the state, because each state has different intestacy laws. And New Hampshire intestacy laws tell the priority of where your assets will go if you have not stated where you want them to go. And regardless of where you want them to go, it will go based on the intestacy laws of that state. So it's not all to the children. It's not all to a surviving spouse if there are children. And it gets more and more complicated if it's a second marriage or some other thing. So if you know what you want to have, and even if not, a basic will is one of the most important things to start out with. And it's the most basic. And if you have an employer, a large employer, typically companies have benefits that do have legal systems inside of them so that you do get discounted attorneys and things like that. But you can work with your advisor, your planner, and the attorney as well, because it is an estate attorney who we do recommend to write these documents officially for you.
Exactly. And to save them and record them, because you could have handwritten one somewhere and then lost it, or your house burned down, or no one knew where it was.
Right. And each state also has its own requirements for what is considered a valid will. So if you do it and then you move to another state,
it might not be valid anymore.
You need to make sure that an attorney who is admitted in that state reviews it to make sure that it is considered valid.
Right.
And then again, we will be speaking about trusts and the capabilities of trusts and when you may need a trust, different types of circumstances for protections, once again, controls and efficiencies. And we'll get into that in a minute. But first, let's talk about, we've spoken about a will. We know that there are trusts, and you and I could do a whole session on the different types of trusts, right?
Very complicated.
Very.
And fun.
Whether they're starting in the will, known as testamentary, or living trusts. And we will, later in this session, talk a little bit about the different living trust and how we use that and some other things. But just to confirm the different legal documents, we've spoken about the will. There are also durable powers of attorney that people should have. And there are durable powers and there are also limited powers. I'm going to tell a little story, which may be helpful to understand the differences of these. So my daughters, Emily and Sarah, they both actually went to Europe for a year or a semester in college. And when they did that, they were already the age of majority. But we are Italian, and we had family over and friends over there. And so my daughters gave the family over there limited power of attorney over their health care matters while they were there in Italy. And they gave us limited power of attorney over their finances while they were over there as well, which was extremely fortunate because my older daughter, Emily, I love her dearly, but typically as she was walking on the plane to leave, she turned around and grabbed me and said, "Oh my gosh, Mom, I forgot to tell you, I got that internship. The day I get back, I have to start, and I need a car." Okay, well, she dropped that bomb, got on the plane, and went to Italy. And fortunately, we had that limited power of attorney because with her FICO score, with her credit, with her accounts, we were able to buy a car in her name while she was in Europe. And when she came back, we no longer could access any of those things because it was limited. It was limited to the time. On the other hand, a durable power of attorney, my mother-in-law, while she was alive, gave my husband, John, and his sister durable power of attorney. And as she got older, when she was in her 90s, she started having falls, and she was hospitalized quite a bit. And fortunately, my husband and his sister were able to pay her bills, were able to take care of the household while she was in the hospital because they had that durable power of attorney. Now, that goes away upon the person's death. So she did pass away, and they no longer were able to do anything.
Yeah, and I can't tell you how many times powers of attorney think that they can still access the accounts and make decisions after, and they can't. But having the durable power of attorney is so critical. I mean, I have had clients that ended up with capacity issues where they ended up with dementia or Alzheimer's, or just got to the point where they couldn't manage finances on their own. And they had a durable power of attorney, and that person, whether it was a spouse or a child or someone else that they trusted, was able to contact me and say, "We need to take a monthly disbursement to help pay for nursing home care," or, "We need to change the assets in the account because her needs have changed. We need to go more conservative because these assets are now more needed for her care." All of those decisions can be made by the durable power of attorney, even if the client that you're working with can no longer make those decisions for themselves.
That's huge. That's absolutely huge. And we have to think about it when it's not needed. And that's the thing that's hard. That's why we're here to guide people, because if they think they don't need it, we'll get it when we need it. And then it may be too late and too difficult.
Well, the process then is much more complicated because now you need to have a hearing and have somebody appointed and go through a lot of extra hoops when you might need those assets immediately.
Exactly. When we come back, we're going to talk a little bit about a healthcare power of attorney as well. Also extremely important.
Yep, absolutely.
Okay. Well, you're listening to Chartered Financial Services on Financial Wellness Weekly on WKBK. We'll be back shortly.
Welcome back. You're listening to Financial Wellness Weekly with Chartered Financial Services on WKBK. This is Liz Newcomb,
And I'm Nina Benton.
And today we are talking about estate planning. We were just going over powers of attorney and how important they are. And now, Nina, why don't you take us through medical powers of attorney?
Yeah, the healthcare power of attorney is also very misunderstood. A lot of spouses believe that they automatically have the capability when something is going on with the spouse, either in a hospital or at a doctor, under a doctor's care, that they can step right in and, number one, make decisions, and number two, be told everything. And that's just not the case, unfortunately. While the patient, if let's say I'm a patient, while I am there and I'm cognizant and capable, I can say to the doctor, this is my husband, you can speak to him exactly and tell him. But if I went in and I was unconscious or something happened to me, they would not speak to anyone if there were not a healthcare power of attorney. So that creates a lot of confusion, and you can think about it at a chaotic time, the impact of that negative. So very important to have set up a healthcare power of attorney when you do your documents. And a lot of laws and rules have changed, so you do need to revisit these with your attorney rather frequently to make sure that they are valid and that they would be accepted at different facilities.
Right. Well, and I think that's just another reason to do this early, right? And to revisit it often.
Yes.
Because again, estate planning is not just for when you're older.
No.
It's for, these accidents and medical events could really happen at any time.
Anytime. You never know in life, of course. It's that elusive crystal ball that we all look for. Yeah. So let's say we now have all of our documents, or we're sitting with the attorney and we've discussed the basics. How do I know if I need a trust? What would be my consideration points?
I think about trusts as money with instructions. And it's a way to make sure that your money does what you want even after you're gone.
Controlling from the grave.
Controlling from the grave, yes.
Cool.
Absolutely.
Okay.
It's magic.
I like that. How much control can I have?
I mean, a lot. It really just depends on what you want to have happen. And you communicate that with your attorney and they write it into your trust. And I mean, one of the big reasons that I see people might want to set one up is they want money to go to their kids, but they don't want all the money to go to their kids as soon as their kids are 18 or 21 if they've passed away.
Right.
Maybe they want their kid to have, $10,000 a year for 20 years and then a lump sum at the end, or,
Or for specific things, like
specific
to pay.
things.
You could be as controlling as you want and
Exactly.
conniving. So if I wanted my kids to be doctors, I could say you only get this money if you go to medical school. And if you
Nina.
graduate, right? They're already past that. So that's just to let you know. But the capability is there that with a trust you gain control and protection also.
Right.
So as you were saying, it doesn't go lump sum in their lap. But let's say, God forbid, a child were getting a divorce and I had put money in a trust for them. And the trust, remember, I set up the parameters of that trust. So in it, I say it can be used at the trustee's discretion for maybe health, education, maintenance, support. And maybe I put a cap on how much per year can come out of it. But let's say that child then is in the middle of a divorce. What would happen to money if it just plopped in the child's lap rather than having gone into the trust, or having that money for their own benefit, but not owning it outright, as is the case with a trust?
Yeah. So that money might have to go to the ex-spouse or be spent on the divorce or
if they get sued.
Yeah.
It's part of a lawsuit, right? Because it's part of their possession. So the benefit of the trust is that they have access to it, yet they don't own it.
Exactly.
So they don't have the control, so it's not considered theirs.
Yeah. I think another really cool thing about trust that people don't realize, they get overwhelmed when they hear trust, but A lot of the times during your life, nothing changes for you. If you're the owner of the account, you put the money in there, you often will be the trustee of the money while you're living, and it operates the same as it did before. But now you have made things drastically easier for your loved ones where the money can stay in the trust after you go. And now your instructions go into place. You've got a successor trustee typically that you've named that just steps right in. It's just such a smooth process. It's just, anyways, maybe you want to add something to
Sure.
that.
So this is a revocable trust we're speaking about right now, also known as a living trust.
Yep.
And so while you're alive, it has your Social Security number as its identification number. It's an extension of you.
Right.
So the taxes get passed through onto your tax ID, onto your IRS, your taxes each year. It's part of you. Yet you have set up, if something happens to you, somebody else can step in and oversee that, number one. And number two, upon your death, you have named beneficiaries. Remember now, we're skipping probate, right? So you've named beneficiaries in that trust. So the control and the protection are there for those beneficiaries. You've stated how you want that money to go out to them or that asset.
Or if you
do. Right, or if you don't want it to, right? And then it becomes, upon your death, it becomes irrevocable.
Right.
So it cannot be changed.
People can't change your wishes.
That's what irrevocable means. They can't change it. But let's look now at, remember we said we could do a whole session on different types of trusts, and we're going to focus today on that revocable living trust.
Right.
But let's just mention some of the other types of trusts, because there is something that's called an irrevocable
Right.
trust that I could set up today. And in fact, most people set up irrevocable trusts primarily for one reason, and that is to get the asset out of their estate now while they are alive.
Right.
With a living trust, remember we said it's an extension of you.
It's still yours.
You control it. You can do whatever you want with it. You pay the taxes on it. So therefore, it is included in your estate upon passing.
Yep.
So typically when people get, either if they're wealthy enough to have a lot of money to put into this irrevocable life insurance trust, irrevocable trust, I gave it away. Typically, people who have large life insurance policies put those policies into an irrevocable trust so that that life insurance death benefit is not included as an asset in their estate. So that's an estate planning tool that can be used for wealthy people or people who have large life insurance policies. And you and John are going to be speaking in a session strictly about life insurance, the different types, and estate planning along with it. So I'll leave that for that. Let's go back to our revocable trust that we have and actually guide people on how, once they set up the documents with an attorney and they have that revocable trust, what has to happen? You know, what has to happen with the titling of an asset? Like, how do I fund that trust?
Oh, that's such a good point, Nina, because I can't tell you how many times people have come into my office and said, what do you mean? Everything's in the trust. We set it up with our attorney. I'm like, you did the trust document, but then you didn't do the homework list that he gave you. You never provided the trust to me. These assets aren't in the trust. The trust isn't listed anywhere.
It's like buying
here.
a car and not filling it with gas.
Right. Yeah, exactly. So you often will have to re-register assets into the name of the trust, providing the trust document to your financial professionals, to your bank, making sure that it's on file.
Yeah, and then, so for example, if I owned an asset, let's say an account, an investment account that I have, the title of it typically would just be Nina's investment account. But if I want to put it in a revocable living trust, I now have to re-register. I have to retitle it. It sounds difficult. It's a form that the institution will give you. But I now have to change it to be Nina Benton, trustee for the Benton Family Trust, whatever I have named that trust as. And typically, your attorney will give you, if you ask them, what is the titling how does it have to read? And they will give that to you. And remember, in a revocable trust, the ID is your own Social Security number. So you have that. And that's what we would want in order to have assets go into that trust. Mm-hmm. The one thing to also remember is that from that point going forward, unless there's a power of attorney on it, we speak to the trustee of that trust.
Or trustees if there
Correct.
are multiple.
So it could be a husband and wife as trustees, and we could speak to either one of them.
I've often seen it where it's, the client and their son, or something like that.
Right. Exactly. Now, when we're talking about titling, I guess this is a good time to speak about the different types of titling of accounts, because we're going to go into different beneficiary listings and the impact of different beneficiary listings. But if I own an account in my own name, an individual account, and let's go back to that bank account or that stock account, typically there is no beneficiary on it.
Right.
So how would that pass if I passed away?
Yep. So that's going through probate.
That goes through the will.
Goes through the will.
Okay. Yep. So if I
or if
said,
there isn't one, it gets figured out in court.
There you go, in the intestate, right? Okay, intestacy laws. So now if I want it to go more efficiently and privately, I can put a power of attorney or transfer on death. Or payable on death on it.
Right. So power of attorney would be during your lifetime. You're giving somebody ability to make decisions.
Thank you.
Yeah. And then afterwards, like you said, the transfer on death or the payable on death designation.
So what I see very frequently that many people do as our parents age is let's say that there's a daughter who has been caring for her mom, and the brothers live elsewhere or just are not involved. And the mom is in and out of hospitals, and the mom says, why don't I put you as a joint owner on my bank account so that you can pay the bills? It will just make everything easier. So now the daughter is a joint owner on that bank account with the mother. The mother passes away, and all of a sudden, a joint ownership, the full name is joint tenancy with rights of survivorship. Mm-hmm. So when you have a joint account, each of you 100% owns 100% of the account. Right? You don't have to ask each other. You don't have to get double signatures. So now, basically what that mother has done is she has named that daughter as the beneficiary.
Right. And maybe that's fine if she's nice, but if she's not, those boys aren't getting anything.
Well, so now in the will states everything is to be divided evenly amongst my three children. Yep. So now all of a sudden the boys are knocking on the sister's door saying, hey, sis, that's mom's only asset.
Where's my third?
Exactly. And the sister could thumb her nose and say, where were you when mom was alive? I've earned this money.
And it's legally mine now.
That's it. She has the right on her side. Remember, beneficiaries trump
the will.
So, or she could then, now it's her asset. Remember, it's hers. She could gift a third to each of her two brothers if she desired. Mm-hmm. But now it's different. She's gifting, and it's not something that they are inheriting, and there are different tax implications.
Especially with investment accounts. There could be a massive difference in the tax treatment of it.
For sure.
Yeah, because I don't know if we want to just touch on step up and cost basis. Maybe not. We won't go into the weeds on that too much. But typically, if you have an investment account and you pass away and it's owned in your name with beneficiaries on it, there's going to be a step up in basis, which means that any taxes, any embedded gains in those investments get stepped up to zero as of the day of your passing.
So let's say that my mom bought Apple at $1 a share, and now I have no clue what it is, but let's just say it's $100 a share, and I inherit it. Well, I inherit the date of death value of that as my cost basis. So if tomorrow I decide to sell it and it's the same, it's $100 a share, and that's what I inherited it at, I get that without any taxable gain versus if my mother had sold it, she would have that $99 a share gain that she would have had to have paid tax on. So
You said that so much more eloquently than I did.
I don't know about that. But anyway, what should this mother-daughter have done? And that's where my slip up when I said power of attorney came in before. The mother should have given the daughter power of attorney over the account. She would have had the same capabilities while she was alive, but then it would have either gone to the will, or to make it even more efficient, she could have done a POD or a TOD on it. So it went to the 3 children.
Exactly.
As she wanted. So there are efficiencies that we can put in as long as we have these proper documents.
Right.
So let's talk about beneficiaries for a little bit and the differences. Something we spoke about in a previous session, the One Big Beautiful Bill, but we didn't mention actually the changes to beneficiary rules, because it used to be if I inherited an account from my parents, that I could stretch out the required minimum distributions over my entire life, which is huge.
And we're talking about retirement accounts specifically
Yes.
here.
IRAs, 401ks, 403bs.
Yeah. So essentially, it would go based on the life expectancy, right? So you had many, many years over which you could gradually take RMDs and keep that money in a tax-deferred status. And that changed with this
drastically.
Act. Yes.
That definitely changed. So now there are things called designated beneficiaries, and there are rules all around who still has, so a spouse still has the capability to stretch, and that won't change. So you can either stretch, a spouse could still, if my spouse passed away, I could roll his qualified accounts into mine.
Right. And it's as if it's yours at that point.
Right.
So that's a great benefit, or it can be.
Or if he were older than I am and he qualified to take money out and I don't qualify yet, I could leave it in his and take money out of it without any penalty.
Yep, I've had that situation with clients as well.
Yeah, so you have some options before you think of doing anything.
Right. And for the children that inherit retirement accounts from their parents now, they typically have 10 years, and they may have to take out some every year if their parent was already of RMD age when they passed. And at the end of that 10 years, guess what? That entire amount that's left in that account needs to come out. And if you didn't plan properly, you might have a large tax hit all in 1 year.
For sure. So what we typically do with our clients who have children, for the children who have inherited an IRA or a 401k, is we will have them take a 10th out each year from the traditional plans. If it's a Roth, then you don't, since it's tax-free, let's try to get the full 10 years of tax deferred. Try not to touch it until the very end. When do you have to touch it?
Yeah. And at that point, it's not a taxable event when it moves out of the Roth, but thereafter, it's going to be in the type of account where you might have gains on the growth after the 10 years.
Right. Hopefully the capital gains rates, the lower rates, if you let it sit for at least a year. Yeah. But then we also have the guidance for our clients. Once they understand these different impacts, because a lot of people don't know that now the kids are going to have this taxable impact over a 10-year period of time. So it may lead to planning on using assets differently during our clients' lives. It's based on how they want their children to inherit the assets. So instead of allowing the stock account, the non-qualified stock account to grow, sometimes they'll use the 401k or IRA so that they use the taxable accounts, let their kids inherit the stock account that would get that step up in cost basis. Or do conversions, as you mentioned earlier, where we can get money in from a traditional account, you pay the tax on it, put it into a Roth so that you pay the tax, not your children, later on, if that's important to you.
Exactly. It also could impact which accounts you name charities as the beneficiary of.
Yeah.
Because they're not going to have to, a nonprofit is not going to have to pay taxes on IRA money, for example.
Exactly.
So that's tax-free money to the charity, and it's saving your kids having to pay taxes on that money. So just another consideration of which beneficiaries you put on which accounts.
As long as you have the other assets to give to your kids.
True.
Let's not disinherit the kids. They won't be very happy with us, will they?
No, but the Humane Society really needs to have more resources.
And so when we do list a charity or some other non-living organization, that's when they can take it as a lump sum, obviously, but the most that they can stretch it out over is 5 years.
Right.
So different rules apply to a lot of different of assets, how we title them, how we leave them to our children, to the charities. Another question is, do you want to tell charities and or your children about who is getting what? Because you as the owner have the capability to change that throughout your lifetime. And it may be that in my early adult years, one organization had a profound impact on me, and yet later on, a different one did. And if I told them that, this is an asset you're going to get, but later on wished I hadn't because I want to now split it between two different charitable organizations, that's your own choice. But that is something that a lot of people like to talk over and think about.
Mm-hmm. Yeah.
Yeah, so charities and also beneficiaries, important to know. Sometimes parents come to me and they say, I've told my child that I am leaving this asset to them and now they don't want me to use it. So I'm not going to use this asset. I'm going to use this other asset for whatever the expense is. And it may not be beneficial to them.
Right. And I would say once you do finally have your plan in place, certainly make sure that your beneficiaries know where to find your documents and your instructions. I know my dad has a letter sitting on his desk with here's the logins, here's where to get to things, here's where my accounts are, my bills. So certainly I think there's reasons not to tell too soon, but I think at a certain point you want to make sure whoever is going to be handling your final things knows where to find those instructions.
Absolutely. So important. So we have, for our kids, they know where our estate binder, we call it. So it's all of those documents are in one place. And my parents, John's folks while they were alive and his stepmom, they all have sent us in different ways. So for example, my parents just sent me a sealed envelope. And on the front of it was the attorney's name, the accountant's name and numbers, and in it are their estate documents. They've told me everything, but I just haven't opened it. So I have that. My stepmother has it just not sealed or anything else, and she has given us the doctor's names and numbers and everything. And this is where, Liz, our planning truly comes in very helpful, and where people want with their estate documents the financial plan. Which gives a listing of all of the assets, where they are, who the owners are, the beneficiaries, and a narrative about this was your wish, this is what you want to have happen.
These were the goals, this is why we set things up this way.
Exactly. So helping guide families is through this process, working with the estate attorneys and accountants as needed, is really what we do.
And we do a lot of it. Making it simple, right? A lot of the times the attorneys are really great at drafting the documents, but they're not in it when it comes to implementing these things, adding them, titling the accounts. And then, it's often the financial advisor that's helping you make the call, report the death, get the assets moved to the beneficiary. So these are things we do often and can simplify for you.
And at our reviews, we look at the beneficiary listings because, as I mentioned quickly before, when we're talking to people, when you set up 401ks, IRAs, life insurance policies, and annuities, you must put the beneficiaries on them. But it's important to make sure that they're still listed accurately because documents get lost and different administrators take over and things can get lost.
So good to review.
And on that note,
this has been Financial Wellness Weekly on WKBK with Chartered Financial Services in Keene. We will be back next Saturday at noon. Feel free to give us a call at 1-800-549-6007 or send us an email at cfs@prudential.com. See you soon.
Take care.